now back in session. You may be seated. Good morning, everybody. Thank you all very much for coming back and being patient with us. Thank you for being patient with us. For all of us who are old enough to remember broken records, some of us remember those, right? Thank you for being patient. I appreciate you bearing with us. If you'll give us your attention, please. Mr. Backwell.
Thank you, Judge. I think when he's talking about a broken record, he's talking about me.
Shoe fits, wear it.
Okay, so I left off over here, and I'm going to start with Ms. Amos, and I think it's pretty evident that, Ms. Amos, I don't need to repeat everything I talked to this group about, right?
Correct.
Were you listening?
Yes.
Okay, and was there anything that I mentioned to this group or any of your fellow jurors that could potentially create a problem with you and your ability to be fair and impartial in this case?
No.
Okay. Hold on for one second. I'm going to ask this as a group. I had meant to ask every juror. There's no way I'm going back over this with everybody, so I'll ask one time as a group. Has anybody in the panel ever had or had a family member or friend who's had a particularly bad experience with law enforcement such that it could influence or affect their ability to be fair and impartial? If you're that person, raise your hand. Okay, and so the record will reflect that nobody raised their hand, and I appreciate it. I'll move on. So, Ms. Amos, we talked about the number one rule, or the most important thing, and that is? Okay, and you're going to follow the law in this case? Okay, now, I keep saying that, but again, I'm not the final word on the law, right?
Right.
Who's the final word on the law? That's right. So, I'm going to go into my box, pull out my Bible, my work Bible, not my personal Bible, and I want to read you something and see if this sounds familiar. This is under a section that will be entitled in your jury instructions, Rules of Deliberation. Okay? The judge will tell you, these are some rules that shall apply to your discussion. You must follow these rules. Not you can, Ms. Amos, or if, based on your personal feelings or beliefs or opinions, you may, but you must, okay? You must follow these rules in order to return a lawful verdict. Number one, there's several, I'm not going to read them all, but number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. That sounds similar to what I've been saying over and over?
Yes.
And do you feel comfortable with that?
Yes.
Now, your job, Ms. Amos, is to ultimately, again, I say to you, as I've said to all of your fellow jurors, can you envision anything in this process that is more important, ultimately, than determining what the truth is?
No.
Do you want to know the truth?
Yes.
Okay. The only way you can get to the truth, and when I say truth, that could be guilty or not guilty, that could be life or death. That's ultimately a decision that you will make based upon the law and the facts. Do you follow me?
Yes.
And you're comfortable with that?
Yes.
Tell me what feelings or opinions you had about the death penalty before you came in here last week. Did you have any?
Not really.
Okay.
I never really thought about it.
You are a C, indicating in your questionnaire that it's appropriate in some circumstances and not appropriate in others. Is that right?
Yes.
Okay. And you now understand what the concept is as it relates, or what the law is as it relates to weighing mitigators and aggravators, right?
Yes.
And if at the conclusion of this case, we've gotten from the guilt phase to the penalty phase, and you weigh the aggravators and you find the presence of an aggravator, whether it be one or more, that is weighty enough to warrant the imposition of the death penalty, or the recommendation for the death penalty, and mitigators that do not outweigh that, could you recommend to the court the imposition of the death penalty?
Yes.
Okay. Now, Ms. Amos, you indicated in your questionnaire you worked out at the Treasure Coast Forensic Treatment Center, right?
Yes.
Do you still work out there?
Yes.
Okay, so for those members of the jury who don't know, the Forensic Treatment Center is where criminal defendants who may suffer from certain mental illnesses that are not competent to be tried will be treated until they're competent, correct?
Correct.
And do you also take defendants who are insane or found insane at the time of the crime? Are they kept out there as well?
We do have some NGIs out there.
Okay.
But I don't really. I deal with, like, I work in a control room.
Okay.
So I don't really deal with the intake and the discharge of any residents there.
Okay.
So I'm not really sure about all the details of that.
All right. For the record, NGI is not guilty by reason of insanity, right?
Mm-hmm.
And, you know, we talked a little bit earlier about that. There are people out there who are truly ill, mentally ill, correct?
Yes.
Any fakers out there?
Yes.
Okay. All right, thank you, Ms. Davis. I appreciate it. Ms. Sims, how are you, ma'am? Good. You have on your questionnaire that your occupation is resolution team leader. What is that?
Customer service supervisor.
I'm sorry, I didn't hear you.
I can't say it.
Customer service supervisor
Okay. And where?
for call center.
Okay. And how long have you been doing that?
I've been doing that for over a year.
Okay. All right. You had indicated in your questionnaire you have a couple of children.
Yes, I do.
All right. How old are they?
My son is 20, and my daughter is 14.
Okay. And when they were younger and getting into fights with one another, did you have the occasion to have to mediate those disputes?
Well, yes.
Okay. Do you think that some of the skills you learned in assessing which one of the kids was telling you the truth will be helpful for you here?
Absolutely.
Okay. You consider yourself an open-minded and fair person.
Definitely, yes.
Now, we talked a little bit before, last week, right? Let's talk about your feelings about the death penalty, since we had not had an opportunity to discuss that. Do you have any feelings about the death penalty?
Well, I indicate yes and no based on the circumstances.
Okay.
Yes.
You said you were a C,
Yes.
that it could be appropriate in some situations and not in others.
Exactly.
All right.
Exactly.
When we talk about this concept of the exercise of free will and personal responsibility, what are your feelings about that? How do you feel about that?
Well, if it's not my personal feelings, if it's, we're here to make a decision, to come to a conclusion by the law. So, it doesn't build around my personal feeling. It just, bring the facts
Right.
to make a determination.
Okay, and obviously at the center of this case is the law and then how the facts would apply to that, right?
Yeah, absolutely.
And as we talked about before, it's not anything we learn outside the courtroom, it's only what happens here, right?
Exactly.
Okay. And do you consider yourself a fair person?
Absolutely, yes.
All right, so I read Ms. Amos one of the rules for deliberations. Let me read you one. This case must not be decided, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions.
Yes.
Right?
Correct.
Does that sound familiar?
Yes.
Okay, and that's how it works. You've never been a juror before, right?
Yes.
Does it give you some level of comfort that at the end of the day, you will have a set of instructions as to how you are to carry out your duties?
Absolutely, yes.
Okay. All right, thank you very much. I appreciate it, ma'am. Ms. Magwood, now we talked, you're our Kaiser University representative, right?
Yes.
Okay. I want to talk to you a little bit about something you indicated in your questionnaire, and it related to the fact that you had a family member who was a victim. Was that a case that was prosecuted?
Yes.
Okay, and was it prosecuted by our office?
No, Connecticut.
Out in Connecticut? Was there anything about the way that was handled by either the investigating law enforcement agency or the prosecutor's office or the courts that was bothersome to you?
No. I chose not to follow the case.
Okay. It was too difficult. Okay. All right. You have heard me talk ad nauseum about following the law, right?
Yes, that's
And you and I talked about that before. As you sit here today, is there any reason that you can envision that would cause you to have problems being simply fair and impartial?
no, sir.
All right. I talked a lot about the death penalty and feelings about the death penalty before you came in here. Tell me what types of opinions or feelings you had about the death penalty in the state of Florida.
I'm not sure about the state of Florida.
Okay.
It is a difficult thing to, have to face a decision on.
Sure.
And I'm not fully supportive of the death penalty, but I do feel that it is appropriate. Based on the law,
Mm-hmm.
so I would follow the law.
When you say you're not fully supportive, express that in words. Where are your, I don't know, objections or issues with it?
I just don't know if we as people have the right to sentence someone to death.
Okay?
However, again, if it is the law, then that's what the decision is based on.
Can I say something to you about the law as it relates to that comment?
Sure.
You said we as a people sentence somebody to death. You, as a jury, will not be sentencing somebody to death. You will be making a recommendation to the court. The court will give your recommendation great weight, as I've said over and over and as the judge read to you. But in the end, if the defendant receives the death penalty, a sentence in that regard, it will come from the judge.
Understood.
Does that help a little bit?
It does.
Okay. And as you've indicated, there are these aggravators and mitigators, and you've got to weigh them. And all I want to make sure is if we get to the end of this trial, despite whatever personal reservations or feelings you might have about the propriety of the death penalty, that if the aggravators outweigh the mitigators, you would be able to, you could, make a recommendation to the court for death. Could you do that?
Yes, sir.
Okay. Any questions or concerns with what we talked about, the law as it defines premeditation?
No.
All right, did that make sense to you, and is that kind of consistent with what you thought, or were you, see what happens a lot of times is a juror will come in and say, wait a minute, I thought premeditation was lying in wait, long-term preparation and planning, procuring weapons, da-da-da-da-da. But in the actuality under the law, it can occur in a very quick period of time.
I understood.
I know you I'm sure you understood it, but did you know that before you came in?
Somewhat, yes.
Okay, great.
Yes.
All right, thank you very much, ma'am. I appreciate it. Mr. Hazel. Oh, no. Mr. Cologne, you're not sitting in the right seat.
Not supposed to.
You guys are trying to mess with me. Okay. Am I right or am I wrong?
You're wrong.
I'm wrong. You know what happened? Mr. Eisenhower did it. You got to get an idea of what kind of person I am. I'm probably out there. All right. Mr. Cologne, right?
Yes.
We talked a little bit on last week, and you had indicated to us that in your questionnaire you were a D. That you said that it was, don't take offense to calling you a D. I'm sure you're outstanding, but, and I want to make sure I read it correctly, and I don't know why I never read this as I wrote it, but generally not appropriate with very few exceptions as it relates to the death penalty. Correct? Okay. Now, as you've had an opportunity, that's what you came in here thinking. But now you've had an opportunity to get a little bit of a flavor for how the death penalty works in the state of Florida and what your role in this process would be. What are your feelings now?
It's a little bit more open to, I guess, the faster case mitigators and aggravators. So.
Okay. So let's, when we use that one hypothetical, I talked about a hypothetical case involving a dead child, right? So first I ask you, the first part of this trial is very simply, did we prove he did it? That's it. And that cannot be influenced. And let me read you something, okay? Just so we're all together. I read 2 of these rules for deliberation. The other one I want to read you is, your duty at this first stage that we're talking about is to determine, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine the appropriate sentence if the defendant is found guilty. Now, we know that that's not exactly how it works because you got the recommendation. But the point of that instruction is that the first part of this trial, there should be no discussion in that room back there asking the what-if question. You follow me? You got to say
yes.
Okay. Can you promise me that if you get back in that room and you're deliberating, that you will not be asking the what-if question?
Yes.
Okay. So if at the conclusion we have established the defendant's guilt beyond a reasonable doubt, we go to the second phase. Now let's go to our hypothetical case. Dead child. The law says if somebody murders a child, that is an aggravating circumstance. To you, it may be an incredibly weighty aggravating circumstance, or it may not be an aggravating circumstance at all. You get to decide that. And you get to assign the weight to that. You choose. But if at the end of the day you were determined under this hypothetical scenario that that was weighty enough to warrant the imposition or a recommendation for the death penalty and was outweighed by mitigation, could you follow that instruction?
Yes.
Okay. And you don't have any concern about your personal opinions affecting or impacting your ability to do that?
No.
Okay. That's right, you work out at Lowe's, right? They quiet in the lunchroom?
Sometimes, depends on what time of the day.
All right, but I'm saying you're getting out of there so you're not being exposed to anything, right? Okay, good. And you can understand why this is a concern and why we want everything to happen in this courtroom, right?
Yes.
Are you a fair and impartial person?
Yes.
Okay. Never any bad experiences with law enforcement?
No.
Okay. Thank you very much, sir. All right, Mr. Hazel, how are you? All right, I'm going to give you an opportunity to correct what you said yesterday. Again, I would ask you, you're having your best day of golf, and Rory's having his worst. You honestly think you can beat Rory McIlroy?
I still think I could.
All right.
I think he shot, 76 a few weeks ago, and shot 72, so.
I guess you could. All right, so anything's possible.
That's right.
Okay, but when we talk about reasonable doubt, again, we're not talking about a possible imaginary or speculative doubt. It is possible you could beat Rory Little, he's the attorney, right? Rory McIlroy, but it's probably not very likely, right?
Yeah.
Okay. Now, Mr. Hazel, you had indicated on your questionnaire a fairly strong opposition to the death penalty. Is that correct?
Yeah, I believe I was one of the 3 in there so far.
Yeah, the E. You were the E. You were E, and you wrote, believe it should be abolished.
Yeah.
And are those your personal feelings?
Yeah.
Can you
Just philosophical reasons.
Okay, good.
I know earlier you asked another juror about it, and he said that there's been cases of innocent people executed, and you asked him if he could name one. He couldn't, and on the spot, I don't think I could have either, but due to the 7 hours of waiting, I've thought of a few.
In the United States?
Yes.
You recognize there's never been a documented case, officially documented case where they determined? Okay, go ahead.
There was,
I'm not talking about people who were on death row and taken off death row.
yeah, I'm talking about people who were executed.
Okay,
Shaka Sankofa from Texas.
okay,
He was the one that said he couldn't have murdered someone because he was raping somebody else.
okay.
Not a great defense, but
Right.
he still was executed for murder.
Not a reasonable defense, you mean?
Yeah.
Okay.
This guy Willingham from Texas. He was the one that was charged for murdering his 2 kids by burning them.
Okay.
But then fire chiefs came in and said that it was an accident. But they were both executed.
Okay.
And it was the West Memphis 3.
I just want to make sure, there's never, these cases were never court findings that an innocent individual was executed.
That's right.
You're saying these are reports from abolitionists of the death penalty who have said these are cases of innocent executions,
Yeah.
correct? Okay. And that's fine. I mean, I'm not here to debate you on this issue. Okay, my position is obvious. Yours seems to be pretty clear too. Are you telling us that as a result of your personal feelings, you could not sit as a fair and impartial juror in this case?
No, I believe I still could. I don't agree with the law,
Okay.
but I also think the speed limit should be a little bit higher on 95.
Okay.
Down the highway.
All right, so you're sitting in the first phase of the case. Your opinion that it's never appropriate and should be abolished would not have any impact, I assume, on whether or not you determine the defendant's guilt or innocence, correct?
Correct.
And then you're telling me, based on, given your philosophical objection and research you've now conducted on the matter, that you could sit in the second phase of this trial and under your oath as a juror, weigh and consider the aggravating circumstances in this case against the mitigating circumstances, and if you deem appropriate, if the aggravators outweigh the mitigators, recommend to the judge a sentence of death.
Yes, and I have an example for it. I was a criminal justice major, and during my, I think it was court procedures, we had a mock trial, and I was assigned as one of the jurors, and we sentenced the person to death.
Okay, in a mock trial.
Yeah.
Okay. All right, thank you, sir. I appreciate it. Miss Moriarty?
Morera.
Okay. You indicated you work as a secretary, is that right?
Yes, sir.
Where is that?
For an immigration attorney.
Okay. Who?
Guerrero Godin.
And where does she practice here?
Here and in Miami.
Okay. And you work out of her office in Fort Pierce, I take it?
Yes, sir.
Okay. And are you also a paralegal or?
I'm currently going to school for paralegal studies.
Okay, here at Indian River?
Yes, sir.
And how far along are you in that process?
So far I've taken 4 law classes.
All right. So what we're doing in here during the course of this trial, does that comport with what your education says is supposed to be happening here?
Yes, sir, and I find it very interesting.
Okay. Do you think you can get some type of credit for this? Hey,
I do love Alabama.
all right. I first asked you if you have any issues or concerns with any of the legal concepts that we've discussed to this point in time.
No, sir, I understand that you have to follow the law in every procedure.
Okay. And when I talked to your fellow jurors, when I first said to whoever I said it to, do you expect me to prove this case beyond all doubt?
No, sir.
Okay. You don't now, but did you then?
Yes, I did know.
Yeah? And do you recognize that this is an absolute impossibility for me to prove anything beyond all doubt?
Yes, it's impossible to prove anything beyond doubt.
Right. Right. Okay. But you recognize, I mean, you consider yourself a woman of some common sense?
Yes, sir.
And so when confronted with a doubt, could you assign reason to that, or could you say that's just a speculative, imaginary, or forced doubt?
Sorry, could you repeat that again?
Yeah, if you're presented with something that is argued to be a doubt, can you look at that and analyze it and say, it's not reasonable, it's speculative, it's imaginary, or it's forced?
Yes.
Okay. Now, you indicated on your questionnaire that you were a C.
Yes, sir.
Is that right? Okay. And before you came in here today, did you have, or last week, did you have any personal feelings or opinions regarding the death penalty?
I've always had the same view of the death penalty.
Okay. Which is
Yes.
what?
That it is appropriate in some cases, depending on case by case.
Right?
Like you mentioned before, second degree, it's not manslaughter. Those are issues that wouldn't be applied to death penalty. Other things that have like aggravators, they should be.
Right.
It could be a possibility of a sentence.
Right. Absolutely. And so even now, you know, not even all first-degree murder cases warrant the death penalty in the absence of certain aggravators outweighing mitigators,
Yes,
right?
sir.
And when we talk about aggravators, I'll talk to you about what aggravators are, but mitigators can be anything, basically anything. And the fact that it's presented to you as a mitigator doesn't mean you have to find it to be mitigating. Do you understand that?
Yes, sir.
Something could be presented and argued to you, this is a mitigating circumstance. And you can look at it and say, I don't think that mitigates anything. You understand that?
Yes, sir.
Or you could say, okay, well, all right, let's say it's mitigating, but it doesn't have virtually any weight. That's your job to do as a juror. You understand that?
Yes, sir.
Okay. You ever get into court with your boss?
No, sir.
No? Okay.
She goes to immigration court. I've never been.
That's down in Miami? Or don't we have a federal courthouse now, right?
It's down in Miami, Orlando, and in West Palm Beach.
Oh, okay. All right. And again, you're going to follow the law?
Yes, sir.
All right. Thank you very much. Ms. Burgess, how are you, ma'am? Good. Good. So what do you got to say about your husband's comments yesterday? I bet you it was a whole night at home. And I asked you, and I think we asked you actually an individual board, Howard. Do you see any, if you and he are together on this jury, does that create any personal problems for you? Because regardless of that, your job is to follow the law, right?
Correct.
Okay.
I also wanted to say that one of my co-workers is
I'm sorry, I can't hear.
Speak up just a little bit, Ms. Burgess.
one of my co-workers is a potential juror here too.
Okay. Here in the room now? Who is it? Oh, okay. Ms. Renz, right? Okay. Is that, if you and Ms. Renz end up on the jury, is that a problem?
No,
Okay, you all get along fine?
we don't really know each other.
Okay, just
It's
work.
how we work in the same
Okay.
office.
All right. Again, because we spoke with you at some length, I just want to confirm, one thing you indicated in the questionnaire is that you have a friend who is in law enforcement, not involved in this case in any way, shape, or form, but regardless, the ultimate issue is the law says that should not affect or impact your verdict in any way, shape, or form. Can you follow that instruction?
Yes.
Okay. And the law also instructs you that, a law enforcement officer's testimony is entitled to no more or less weight because of who he or she is, right?
Yes.
You follow that?
Yes.
Okay, so what we didn't talk to you about was your position on the death penalty. Did you come into this process with any views or opinions about the death penalty?
In some cases, when you read about cases that are out there, you can see why there could be the potential of death penalty.
Okay.
That's it. I don't have a strong opinion one way or the
Ms.
other.
Burgess, you got to speak up because she can't hear you.
I don't have a strong opinion one way or the other.
Okay. And so are you open to the possibility that this case may be different than other cases you saw on the outside that maybe potentially were death penalty cases, but this could also potentially be a death penalty case depending on the facts?
Yes.
Okay. All right. When I talked about circumstantial evidence, were you comfortable with that concept?
Yes.
Okay, and does that make sense to you?
Yes, it does.
All right. When I said that I don't have to prove motive, how did that strike you, Ms. Burgess? What did you think of that?
I wasn't surprised.
No?
I think you need to know the motive. It's either you did or didn't do it.
Ms. Burgess, I'm sorry, she can't hear you.
I don't think you have to prove the motive at all. Whether he did it or didn't doesn't know why. It doesn't mean why he did it. He just did it or didn't do it.
Would you like to know?
Sure. Curiosity, yes.
Okay. Thank you. You did follow along?
Yes.
Mr. Green?
Yes.
How are you, sir?
I'm fine, sir.
You were a prior juror in a possession by firearm by convicted felon case,
That is
right?
correct.
Okay. And was that here or somewhere else?
It was in St. Lucie County.
And again, other than being not as long in duration as this process, everything pretty much similar?
Correct.
And during the course of your deliberations in that case, were there any outside issues injected into your deliberations that had to be addressed?
There was none.
Okay, great. Feel that at the conclusion of that case, you and your fellow jurors came to did you arrive at a verdict?
We did.
And what was your verdict?
It was guilty.
Okay. And at the conclusion of that case, do you feel like everybody had their say in the deliberations?
Yes, they did.
Okay. You also, I just want to ask you indicate your wife is an attorney in Martin County.
There's, local government law for the Board of County Commissioners.
Oh, she works for Martin County, Board of County Commissioners.
That is correct.
What is her name?
Crystal Story.
Okay. She's been down there quite a while.
Yeah, she used to be here.
Okay. With regard to your duties and responsibilities as a juror, you know what they are. Can you do it again?
Yes.
All right. As we talk about the death penalty, you indicated on your questionnaire that you are the C. You are appropriate some, not appropriate in others. Is that correct? And again, do you feel comfortable with the law as the judges described it to you and as we've been discussing? And do you feel comfortable in your ability to follow that law?
I do.
And you're going to follow the law as the judge instructs you in this case?
I shall.
Thank you very much. Ms. Rowan, how are you?
Good.
You were a juror before as well, right?
Yes.
And was that a criminal or a civil case?
DUI.
A DUI here or some in Broward? Okay.
Ms. Brown, let me have you speak up for us, please, just a little bit.
Broward County.
Okay. The problem is those microphones don't exist over there where you guys are, so you're in a tough spot. And did you all arrive at a verdict?
Yes.
Okay. Did you find during the course of your deliberations that anybody attempted to inject emotion or sympathies or bias into the process? Okay. And you recognize the reason we tell you, and let me read you one more instruction as we go through these. Your verdict, the very last thing the judge will tell you in this section of rules for deliberation is your verdict should not be influenced by feelings of prejudice, bias, or sympathy.
Yes.
Right? You remember that from back in Broward County?
Yes, sir.
Okay. Is that a good rule, do you think?
Yes, sir.
Why do we tell people not to allow those type of things to influence their verdict?
It's not fair to,
Sorry.
it's not fair to the person to put your feelings.
Ms. Brown, I'm sorry. Speak up just a little bit so she can, you said not fair.
It's not fair for the person to bring your personal feelings into it.
Do we have like a microphone we can give them?
I don't think so.
Oh, they don't have that anymore? Okay, just try that. You indicated on your questionnaire that you were an E, that you did not believe the death penalty is ever appropriate under any circumstances. Can you tell me, is that a personal feeling based on philosophy, morals, on a religious basis? What is the nature of your position?
This is my personal feeling, but understanding it's just recommendation. I'm comfortable with it.
Okay, I need to make sure that we're clear though, what the judge, when you use the term just, it sounds like it minimizes what it is. It's, as the judge tells you, your recommendation will be given great weight. You understand that?
Yes.
Okay, so I ask you, based upon your answer in the questionnaire and your personal feelings, what effect or impact do you believe that could have on you in the penalty phase of a case? That second part of the trial.
I'm fine with it after hearing all of the points of the weight.
The way to wait, okay. All right, so if at the conclusion of this proceeding, and certainly your feelings would not affect or influence the first phase of the trial, that is, did we prove he did it, right?
Right.
Okay, so then at the second phase, in the event that you find there's an aggravator that warrants the death penalty, and it outweighs the mitigators, could you make a recommendation to the judge for death?
Yes, sir.
Okay, thank you. When we talked about premeditation, did you have any concerns about how the law instructs you premeditation can be established? No?
I'm sorry.
Yeah, when I talked about premeditation earlier, the legal definition of premeditation, did you have any concerns with how the law defines that?
No, I didn't have any concerns. I understood that premeditation is, if they go ahead and do it, even they have at a point, they have a chance to think about it and stop it.
Absolutely. Right, to think about it, reflect upon it, and then act.
Yes, sir.
All right, thank you very much, ma'am. You gonna follow the law?
Yes, sir.
All right. Ms. Smith,
Yes,
how are you?
I'm okay, thank you.
You're hanging in there, right? What, I know you are now a stay-at-home mom, but have you worked outside the house?
Yes,
What'd you do?
I was a business systems analyst for Liberty.
Liberty Medical?
Ms. Smith, I need you to speak up.
I was a business systems analyst for Liberty Medical Supply.
Okay, how long was that?
That was probably about 3 years before I had kids.
Okay. Now, Ms. Smith, you were a juror as well, correct?
I was.
And you indicated that that was some type of a lewd and lascivious case or a sex case of some sort?
Yes.
Okay. Again, I asked the same question I asked all your fellow jurors. When you got back there, was there any sympathy expressed or any bias or any outside influences brought to bear on your deliberations?
No, there wasn't.
Okay.
And we never deliberated.
You never got to deliberate?
No.
Did it resolve itself before you got to that point?
Yes, he stated no low consent risk.
Okay. With respect to the death penalty, Ms. Smith, given it any thought before you came in here today, or this week?
I really haven't.
Okay. Now that you've had an opportunity to hear how the law works and what, how this process kind of plays out, what are your feelings or impressions?
I would just follow the law. I don't have strong opinion one way or the other, so I would have to follow the law.
I mean, it's kind of on a very basic level. This whole line of questioning that I've been asking is somewhat unfair, isn't it? Because I can't talk to you about what the facts are in this case.
Right.
I can't even talk to you about the aggravators that are going to be applied in this case, because it's not about getting you to commit to anything at this stage, other than to follow the law.
Right.
And that's what you're saying, you're going to follow the law?
Yes.
Okay, thank you, John. Ms. Martinez, good morning.
Good morning.
Make sure you speak up.
Yes, good morning.
I have on your questionnaire that you're an ELL paraprofessional. I don't know what that stands for.
Okay, I work at Anderson Middle School.
Okay.
I help students who don't speak English very well to complete their tasks. I go in the classroom and I help them.
Okay, so what's that? English is a second language type?
Yes.
Okay.
Yes, that is one of my concerns here.
Yes.
That my second language is English. My first language is Spanish.
Okay.
So, in my job, I go and I read the instruction and I help them to complete their task, to do what they have to do. But because I translate into Spanish to them. But here, I know that this is an important process, important case.
Sure.
And that's one of my concerns, that maybe, maybe there are some legal words that I don't understand, or
Okay. But I mean, you speak very good English.
I do speak, yeah. I don't speak so fluently, but I do understand.
Okay.
I understand English and I speak, but what I mean is,
Well, here, tell me this. We've talked, the judge has read a whole bunch of instructions. I've been talking for hours and hours and hours. And you know, are there any any legal terms that I've used that you don't understand up to this point in time?
yes, like yesterday, I mean, you speak fast, right?
Tell it to the lady typing. She can, yeah.
Like yesterday, you said burden, like that word, I had to
Okay.
look and
So
translate
here,
it.
let me see, the burden of proof. I use it in that context,
Yes,
right?
yes.
Okay? Remember, we talked about the Constitution being at the foundation of this process, right? And that the defendant is presumed innocent. Do you understand that?
Yes.
That doesn't mean he's innocent, but it means as you sit here today, you have to presume him innocent because you know nothing about the case, right?
Okay.
All right? Then, the burden. As the government, Mr. Eisenhower and I accused him of committing murder. And so it's my burden, my job, to prove to you, right? It's like I'm carrying a load. To prove to you his guilt beyond a reasonable doubt. Now you know burden, right?
Yes, I do, sir.
Okay. Any other words?
No.
Okay.
So far.
But really, truthfully, this is only you can tell us this. Do you feel as if there's a potential, or do you feel uncomfortable in your role as a juror because of your personal feelings about your ability to understand what we're talking about?
My concern is that it's going to be a process. We're going to have witness, you know.
Okay.
And my concern is if I don't understand
I got you.
all the words. Then
Yes. Okay. Other than that, and that's something the judge will have to take up, but other than that, anything about what we expect of you here as a juror that creates any concern for you?
No.
You a fair and impartial person?
Yes, I
Okay. Can you follow the judge's instructions on the law?
Yes, I can.
And when we talked about the death penalty, you indicated on your questionnaire that you were a C, that it's appropriate in some and it's not appropriate in others, right?
Yes.
Okay. And do you have any other strong feelings that you think could impact or affect your ability to perform your duties in the penalty phase of this case?
No, I don't.
Okay. Thank you for bringing that to our attention. You're going to follow the law?
Yes, I do.
All right. Ms. Fontano,
Yeah.
how are you? I know you're our crossing guard, right?
Yeah.
How are the kids getting to and from school all this?
Someone's covering my post.
Okay, good. All right. We talked quite a bit to you last week, I know, so I just want to touch with you on the issue of the death penalty, because that's not something we got to talk about. When you came in last 2 weeks ago now, did you come in with any strong feelings or opinions or emotions about the death penalty?
No, it was a C.
You are a C, that's correct, and you remain a C today?
Yes, sir.
Okay. And at the conclusion of this case, if we convince you beyond a reasonable doubt of the existence of an aggravator that in your mind is weighty enough to warrant the imposition of the death penalty and outweighs the mitigators, can you recommend to this court a death sentence?
Yes, sir.
Okay. And if you were the foreperson in this case, which is absolutely possible, at the conclusion you would have to sign both the verdict form and the recommendation to the judge. Could you do that?
Yes, sir.
Okay. Are you willing to apply the judge's instructions on the law?
Yes.
So, I talked to you about some of the rules of deliberation. I go back to my book. And here is the very last words you'll hear from the judge at the conclusion of this case. And I'm going to find them, I promise. Okay. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them, because for over 200 centuries we have lived by the Constitution and the law, and no juror has the right to violate rules we all share.
Yes.
That kind of comport with what I've been talking about for a day and a half now?
Yes.
Okay. You gonna follow the law?
Yes, sir.
Okay, thank you, ma'am. All right. You think I was gonna make it over here, did you? How's my back look? I don't have any strings or anything hanging off. I mean, you guys have been looking at my back for a day. I apologize for that. I'm going to start right with you, Mr. Burns. How are you, sir? Good. Okay. Because we spoke, I'm going to go cut right to the heart of the issue. You are one of the jurors who had indicated strong feelings regarding the death penalty. You identified yourself as an A before you came in here, correct? And those are your personal feelings and opinions, and do you recognize now that I've read over and over that your job is to apply the law, that those opinions must be left outside and you must perform your role under the law? Okay, and so, again, I will say to you, as I've said to some of your fellow jurors, in the event you hear all of the evidence in this case and I don't show you a single aggravator, at the end of the day you say, where's the beef? There is no aggravation in this case. The law says you must vote for life. Can you do that?
Yes.
Okay, and again, if I do show you an aggravator and you look at it and you say, well, it's not weighty enough for the death penalty, you must vote for life. Can you follow that instruction? And finally, if you find one and and you think it's weighty enough for death, but the mitigation outweighs that aggravator, the law says you must vote for life. Will you follow the law?
Yes.
Okay. You know, when it comes to these issues of mitigation, it's ultimately your decision because there are some certain statutory mitigators that might apply. So a statutory mitigator is something defined by law. So for instance, one is, and again I'm talking about things that won't apply to our case because that's the way this works, that the defendant was an accomplice in a capital felony committed by another person and his participation was relatively minor. So if we're in a case where the defendant had an accomplice, that could be a statutory mitigator. You could look at that and that could be very weighty. Or it could be little weight. Or you might find it doesn't apply at all. There's also another form of statutory mitigation that could be just about anything. You get it that it's your job to determine, number one, whether it's been proven, and number two, how much weight to give it.
Yes.
And you will follow the instructions in that regard?
I will.
And will you follow all of the laws in this case as the judge instructions? Okay. Thank you very much, sir. Miss Barthold, good morning. How are you?
Good morning.
We have not got an opportunity to talk to you, right? Your occupation is a nurse. Where do you work?
I'm working for a kidney center.
Dialysis center?
Yes, sir.
And where?
In Okeechobee County.
Oh, really? So you travel back and forth every day?
Yes, sir.
It's a long drive, huh? You know, when I talked to some of your fellow jurors, I had mentioned how early in a lawyer's career, a prosecutor's career, we talk about picking jurors and trying to identify people you think might be better jurors for you and how some professions are sympathy-based. Nursing is one of those professions. You are here to help people, right? It's a sympathetic, caring profession, and of course, God bless you. We're glad to have you, especially when we're sick. But I wonder, what do you think about that generalization? Is that a fair generalization for me to be concerned about somebody's profession making them more likely to be sympathetic?
Well, in this case, I guess we have to go by the law.
Right.
We cannot go by our own feelings. We cannot do, like sharing our sympathy in this case.
Mm-hmm.
But me personally, as a nurse, I am very caring.
All right, I see you getting emotional. The last thing I do is make you cry and then get all the women on this panel mad at me. So, I'll ask you one quick question and I'm moving on, okay? Do you feel that your feelings and emotions about what we're doing here could affect your ability to carry out your duties as a juror?
I should say no.
You're going to say no? Okay. All right. Okay. Thank you very much. Ms. Chatham? You're right, it is Cheatham. I got to spell right and everything. I just can't read my own chicken scratch. We spent a lot of time talking to you, but we did not talk about the death penalty. I asked you the same questions that I asked Mr. Burns. Now, you've indicated on your questionnaire you're an A, correct? All right. And now you understand that the law is very clear that the death penalty does not apply to every murder, right? It doesn't apply to many types of second degree manslaughter, et cetera, et cetera. and it doesn't even apply to all first-degree murders. Are you with me? Then you accept that as the law and follow that. All right. Furthermore, the law is, as I talked to Mr. Burns, that if you don't find aggravation in this case, you must vote for life. Can you do that? And if you do find aggravation and you think it warrants imposition of the death penalty, the law says, or doesn't warrant imposition of the death penalty, the law says you must vote life. Can you do that? And why can you do that? Right? I mean, okay, so there's nothing wrong with you having these strong personal opinions. And we've heard E's mention this, and B's, and C's, and A's, and everybody. It doesn't really matter. I don't care what you think of the criminal justice system or what you think about penalty or punishment or crime and punishment. You can set, as long as you can set all that aside and follow the judge's instructions on the law. Can you do that? Okay. Any questions or concerns about any of the legal concepts that we have discussed throughout this proceeding? All right. Thank you very much. I appreciate it. Mr. Rydberg. Okay, so that's right. We talked. You're our FP&L mechanic, right?
Yes.
What do you do out there?
I work on various systems out there. A lot of valve work, pumps.
Are you in the nuke plant or are you out in Indiantown?
The nuke plant.
Oh, okay. Okay. Are you like a nuclear
Mechanic. I mean, no, not an engineer or anything like that. But
Okay.
not a car mechanic. So, yeah, like I said, a lot of work on different valves and fans and
Okay. Now, how long have you been out there with them?
about 3 years.
Okay. Can I assume there are some pretty strict rules and regulations that go with working on parts of a nuclear power plant?
Oh, yeah.
I mean, is it like a manual?
Well, we have different procedures that we have to follow.
Okay. You follow them pretty specifically?
Yes.
I mean, we all want to know, we want to hear you say that.
Yeah.
So it's no, in that regard, no different than what I'm asking or what we're asking you to do here in a certain sense, and that is to follow the rules, right?
Yes.
You indicated on your questionnaire a position D, which is generally not appropriate with very few exceptions, correct?
I thought I'd put C.
Okay. Well, maybe, I don't know. Do you have this questionnaire?
But maybe it was D.
That's fine, whatever.
Yeah.
So are you telling me now that you've heard how this works and what you do, that it's a possibility you're a C? D. You were a D, now you're a C.
Okay. No, I would still say in some cases, it's not appropriate.
Sure.
In some cases, it is appropriate.
Okay. And so before you came into this process, no real strong opinions or belief systems one way or the other regarding the death penalty?
No real strong ones, no.
Okay. And certainly you recognize your obligation as a juror is to set aside any feelings or opinions you might have and apply the judge's instructions to you on the law, right?
Yes.
And would there be any situation where you could envision yourself incapable of doing that in this case?
As far as the law is written, no.
Okay. We talked about issues of premeditation and circumstantial evidence and how you assess credibility. You comfortable with all those things?
Yes.
Okay. And in the end, are you going to follow the judge's instructions as he provides you that on the law?
Yes, I will.
Okay. Thank you very much. And Mr. Howard, how are you, sir?
I'm fine.
Yeah? Okay. You indicated on your questionnaire that you had family members or friends in law enforcement?
Deceased member, yes.
Okay. And again, as I've asked over and over to your fellow jurors, is there anything about that that could cause you to be fair and impartial?
No, I can be fair.
Okay. And that you promise us you will follow the judge's instructions, that you will not give any one witness's testimony any more or less weight just based on who they are?
I can do that, yes.
Okay. Now, you told us in your questionnaire that you were a C as it related to the death penalty, appropriate in some cases, not in others, but you made a comment in the comment section that you were, quote, against it.
Well, my personal feeling is that I'm against it.
Okay.
I can put that aside and not. I can follow the law.
Okay. All right.
Follow the law in my life, I'm not going to change it.
Okay. And you feel comfortable knowing that you're going to have a very specific set of instructions that will guide you both through the guilt phase and the penalty phase should we get there?
Yes.
All right. Let's see, since we're getting very close to the end, right, you're it. I want to see if you were listening to me yesterday. So if you're asked a question, because I'm not the last one who gets to talk to you guys, but if you're asked the question during this process, and you don't know the answer,
I'm saying I don't know the answer.
okay, how about can you say, will you promise me you'll say, what's the law say about that?
What's the law say about that?
Okay, and the point of that is, we can't expect you folks who have, you worked in the railroad industry, is that right?
I did for
Yeah.
a number of years here.
I can't run a train, I don't know how to dispatch trains, I don't know, you know what I mean? And if I came to the job, you'd have to teach me how to do it. So we can't expect you to come in here having never been a juror and know what the law is. So the appropriate answer should be, what's the law say? And then, what we need to determine, Mr. Howard, is having been informed as to what the law says, whether or not you can follow that. Because people's personal beliefs might impact their ability to follow the law. That's what we're here about, right?
Yes, sir.
Okay, you're going to follow the law.
Yes, sir.
Thank you, sir. Miss Wren, how are you?
Fine, how are you?
I'm fine, and we talked to you a little bit. Do you have a son in the Navy?
Yes.
Where is he?
He's in Washington, State of Washington.
Oh, okay. Fixing to get cold. Is he from Florida?
He has.
Is this his first year in?
No, he's been in for 7 years.
Oh, 7 years. Okay, great. You indicated on your questionnaire also that you had family members or friends that might have run-in with the criminal justice system. Can you tell me, was that here or somewhere else?
It was here.
Okay. Anything about the way our office or the court system or the cops handled that case?
It was fine.
Fine?
No problems with it.
Okay, great. You had indicated on your questionnaire that you knew, I guess it was Battalion Chief Beach, and he's retired, I think, right?
I don't know because it was a long time ago.
Okay.
My niece was she worked for the fire department.
I see.
And he was her chief.
Oh, all right. So we're not calling him, and he's retired, and so that
Yeah.
resolve any issues you have with that?
Right.
Okay. And even if we were calling him, the law would say you can't give his testimony any more or less weight. Would you be able to follow that?
Yeah.
Okay, great. You indicated on your questionnaire also a C, right? Had you given any thought to the death penalty and how it worked prior to coming in here a couple weeks ago?
A little bit.
Tell me about that.
Well, there was a case in my ex-husband's family.
Okay.
My daughter's cousin, that it was in New York and they don't have the death penalty.
That's correct.
But they probably would have applied it.
Okay.
They had at that time, so I thought about it then.
You thought about it under those
Yeah,
circumstances?
Under those circumstances, yes.
Okay.
But I understand that you have to follow the law, and sometimes it's appropriate, sometimes it's not, is the way I feel.
Okay. And ultimately, the real question is, we've been asking because I got to know now whether or not you can do it. If you think it's appropriate, I can't find out that it can't be done when you're back there in the room.
I can do it.
Okay. Are you a fair person?
Yes.
You're gonna remember now. I want you to be very clear on this, because I almost did it myself. You say you hear the evidence. It's my burden, and only my burden. And I'm going to prove this case from that witness stand, and I'm going to prove that case with photographs and exhibits and other forms of evidence. And it is upon that and that alone which you must base your verdict. Can you do that?
Yes.
Okay. You're going to follow the law. Thank you, ma'am. Mr. Watson.
Yes.
One of our teachers, are you salty or are you jaded?
I love what I do, and I've been doing it for 39 years.
Yeah?
So I don't consider myself jaded.
No?
Just, I love what I do.
39 years. Well, like when did teachers retire? You work till forever?
Well, you can at 62, but I did 12 years in Indiana, so
Oh.
I couldn't even go into drop until I'm 62. But as long as I feel good, I'm going to keep doing this job. I love it.
Where are you teaching?
This year I'm doing 6th grade at Oak Hammock. I do reading.
Okay.
And I was out there this morning making sure that my kids would have the appropriate things that they needed for today.
Lesson plans and all of those good things?
Absolutely.
That doesn't change, does it?
No.
Look, I know you'd probably rather be with your kids and teaching and doing what you love. But man, well, I always loved it when we had substitutes. That was the best time. That was a good time. So at least keep that in mind. The kids are happy. I'm not saying that they don't love you, but they love those substitutes. You indicated on your questionnaire that you did C and D, and you put undecided in there, right?
Right. I've learned a lot in the last few days
Okay.
about what the differences are
Right.
between the A's through the D's and whatever. But I guess when I read the question, I was thinking that any kind of murder charge might become a possible death sentence.
Sure.
And now I know that's not the case, and that there are lots and lots of strictures involved with when something has to be charged as a first-degree possible death sentence. So, I feel a whole lot better about that.
Okay. So when I tried to make an analogy that I thought would work for you guys, and the one I came up with yesterday talked about me driving a car and looking down to change a station or getting distracted and then kind of rolling through a stop sign. Not the most aggravated kind of running a stop sign, running a red light, right? It's just an accident. It was inadvertent. I'm going to pay a fine because I was driving and I should have been paying better attention. But I'm going to pay a fine, right? But now when I add into the equation that I'm in a hurry and I know what I'm doing and I look around and I run that stop sign, maybe my fine should be a little higher, right? You agree with that?
I think personal responsibility is extremely important. It's one of the things that teachers almost universally apply. That children don't learn it. They have to be taught. It's not something that they grow up automatically knowing.
Right.
And so when they're sixth grade, they can be the worst behavior kids that you'll ever see. But eventually, the good comes through. But you still have to demand the responsibility.
Right, but as a society, do you see that there has been some minimization of personal responsibility? I mean, aren't we always making excuses for people's conduct?
I think as a society, yes.
Okay.
I think in my classroom, no.
Okay.
If you start out and you have a certain level of expectation,
Right.
you can always make individual differences. You don't have to be the hard-line person all the time. But children expect that kind of security that comes from having rules that they know where the boundaries are.
Right, but is it your job as a teacher to raise my child?
Most of the time, yeah. Absolutely. I mean, you probably know as well as anybody what kind of families we deal with every day in public education.
So we talk about now all of a sudden, as I use this as an analogy for how the death penalty scheme works, because as you'd indicated, you're in this CD area, not really understanding. Now we go from inadvertence or inattention to intentional. Now it's raining and it's a school day and there are kids at the school buses and I'm speeding through a residential neighborhood because I want to get somewhere fast and I got bald tires on my car, right? And I spin out and I kill someone. That makes that run a stop sign and kill someone. Now that makes that stop sign time aggravated, right?
Absolutely.
Because that's how aggravation works. So in the end, as far as the law is concerned, there are only very specific aggravators that can apply. And your job is to determine, did I prove it to you? And does that warrant the imposition of the death penalty? And if at the end of the day, I prove the existence of an aggravator, and you determine it's weighty enough to warrant a recommendation of death, and it outweighs any mitigation, can you promise me that you will, excuse me, I don't want to, could you recommend to the judge death under those circumstances?
I would definitely follow the law, but at the same time, I'll sit here and tell you, I have to be absolutely certain that those mitigators and those aggravators come up to the level that I understand are important.
Okay. Well, that's, in the end, it's your job to weigh them. There's no legal guidance in that.
But my answer is yes.
Okay. All right. And other than that, you're going to follow the law?
Absolutely.
Okay. Thank you, sir. Mr. Grogan, how are you, sir? We talked a lot last week, right? So I don't need to spend a whole lot of time. We did not talk about the death penalty. You've now heard me talk about it for a day and a half. You had initially indicated you were a B. Do you understand that the law provides very strict and specific guidance as to the circumstances under which you can recommend a death sentence?
Yes, I'm comfortable with
And you can follow that instruction. And just to go through them, in the event that the law tells you that you must recommend life, can you follow that instruction and make a recommendation of life? Anything that we've talked about, premeditation, circumstantial evidence, burden of proof, weighing testimony that creates any difficulties or problems with you. You person who has some degree of common sense, do you think Mr. Eisenhower and I here can pull the wool over your eyes? He's a pretty sharp guy. Okay. You don't, I mean, we're not going to, you will know something that's unreasonable. Is that fair to say? Okay. What do you do for a living? I didn't ask.
I have a small home repair business.
Okay, great. Thank you, sir. And our final teacher, Mr. King, how are you, sir? Tell me, where are you teaching? What do you teach?
I teach at Alpine Flats, K-8 school, special education inclusion teacher.
Special education inclusion teacher. That sounds tough.
Sounds wordy.
Well, what is it?
I work with students with disabilities. I go into other teachers' classrooms and work with the students with disabilities.
Physical or emotional disabilities?
Could be a bit both.
Could, okay. And so is this what they call mainstreaming, where you take the kids and you put them in that might have difficulties? Yes. Okay. And so do you travel from class to class?
Not with the same group.
Okay.
Different classes.
That sounds like a pretty heavy job.
Teaching is always heavy.
Have you always done that type of teaching?
I taught science before, general education, and I had a self-contained classroom, meaning that I had all students with disabilities.
Okay. So to me, it sounds, in my mind, I envision somebody who's got to be a very patient person and a very caring person to have a profession of that nature. So you heard me talk earlier about teachers and sympathy and what role or position or place that doesn't or does not have in a courtroom. Should I be concerned that you are a sympathetic person that it could potentially affect how you carry out your duties as a juror?
No.
Okay. And do you understand what your legal obligation is in this case?
Yes.
Okay. I don't remember, what were you, a C in the...
Yeah,
a C? Okay. Had you given any thought to the death penalty before you came walking in here 2 weeks ago?
No.
No? Not at all?
Not really. Much.
Okay. And as the law explains it now, do you have some comfort in your ability to execute those duties?
Based on what you have explained.
And again, it's not, if I say it's not consistent with what the judge tells you the law is, who are you going to listen to?
The judge.
Right. Okay. All right. With regard to the concepts of premeditation and circumstantial evidence and your job as a juror, going over all of those, do those kind of make sense and kind of what you thought you would be doing when you came here?
Yeah.
Okay.
Makes sense.
All right. And could you envision any circumstance under which you would be unable to follow the judge's instructions on the law?
No.
All right. Thank you, Mr. King. I appreciate your patience. I know things can't last. Your Honor, I have no further questions. Thank you.
Thank you. Defense? Folks, thank y'all for your patience. I'm going to turn it over to the defense. Ms. Celadoni will have the opportunity to talk to y'all. If y'all will please be as patient with her as you have been with me and Mr. Backadall, she will appreciate it. Just make sure y'all speak up so me and the nice ladies can hear you.
It's going to get a little trickier for me because, of course, I have to bring here. Hi. The Digital TV welcomes you. What I'm going to do now is probably going to get you all confused more than you already were when you first came in here with your original opinions and now the opinions you feel you might hold. This is a lengthy process. This is not your ordinary run-of-the-mill grand theft, retail theft,
battery case in which this is the forum that you think you might want to try out your newfound way of thinking things through or following the law. This happens to be the actual, in the state of Florida, highest crime you can be charged with the highest penalty that somebody can receive if they're found guilty. So if any of you are sitting here and you're like, God, I know we've heard a lot of people talk about, oh, you've educated us so much. We're so thankful. This is, this is great. This is not Indian River State College Criminal Law 101. What it is the first-degree murder trial of Eriese Tisdale. So for any of you that think that this is that time for you to say, well, let me see if I can follow the law. Okay? By the time we get finished talking to you, and we get finished with the jury selection process, which is, I'm going to sit here basically and talk to each and every one of you. I understand it's grueling. Some of you it's boring. Some of you are just waiting for that one question to come that you can nail home to walk out that door. But personally, if that's your thought and your feeling, please share it with us before this process is finished. You're going to have plenty of opportunities. And the judge at the end is going to also give you opportunity. Because this is, obviously, the most important process for us in order to get a fair and impartial trial at jury. And that is what this is about. And it is a process, and it is long. But we're not going to make excuses for ourselves. We're not going to apologize. Because at the end of the day, when the 12 of you are sitting up there and you're hearing this case and you're deciding the fate of Eriese Tisdale, we need to know that you have set aside all those personal beliefs on the outside. And at no time, whether it be opening, closing, middle of the trial, when that first picture of Gary Morales is shown to you, dead, dowel sticking in his head, that is not the time for you to decide, oh God, I should not be here. So as nice as it's all been up until now, and how we can, we talk about mock trial, we talk about how you can imagine the worst of the worst situation to find an aggravator. We are going to give you all of those details as the case progresses and the trial progresses. However, for now, we need you to really dig deep down inside when you're giving us those answers, because it's all going to come down to when the evidence is presented, when your verdict is formed, when the first phase is done, and you're into that second phase. Remember, you will never get to that second phase unless you find Eriese Tisdale guilty of first-degree premeditated murder. That is the only way we get to the second phase. So everybody here that's already said that they can set aside their feelings, emotions, their opinions, their own upbringing, and their own way they were raised, and their own insight, and decide the first phase of the case, that's great. But once that phase is done, the guilt has been decided. The facts are there. Okay? And I am here to talk to you about that second phase. Now, a few of you we've actually talked to about the death penalty, but most of you we haven't. So we may go back and ask a couple of death penalty questions on those who we've already talked to. But for the most part, I'm going to be talking about the death penalty. I might trickle into a couple more issues if they come up with the group. But that's what I'm concentrating on. So when I finish talking, don't think, oh God, we get to leave. She's finished talking, thank God. Because there's going to be more of us talking to you too. So, and it's the only opportunity that we actually get to have this one-on-one with everybody and dig a little deeper and push a little harder and ask for that opinion to come out, because we know we know that everybody in this room, whether they're 18 or 70, has formed opinions and lifestyles and life experiences that as much as you want to believe, you can set it aside. At some point in that second phase, once all the facts and circumstances and evidence has been presented, you're going to be making an individual decision. And that individual decision is going to be coming from deep inside of you. And so all those feelings and emotions, yes, we would think you would want to maybe keep them in check, but the reality of it is, in the second phase, if we get there...
Judge, can we approach, please?
Sir? Folks, I'm going to just take a quick break. I know some of y'all probably need to use the restroom, so if y'all need to go, now's the time. They're out here on the right. Y'all should know where they are. Come right back, though, please, so we can proceed.
So am I, so I can always do.
Retired or retired? One to go.
Well, at first I was tired, now I'm retired. And then I'll be expired.
Still think you need a 45? That's what we care. I thought those were men. No, we go 45. Are those administrators? No. 45. And then I'm going to go on there.
And it's all up again?
So it'll be easier to line you up and get you back in when you climb over everybody.
We're just